No. Microphone.
Good day, everyone, and welcome to the Day 3 debate between the Hague University of Applied Sciences and University of Chile. The two teams have received a topic 7 days in advance, which for today's debate is that the global classification of gig economy workers as independent contractors undermines international cooperation on labor rights. Before we find out the positions for each team, of course, we'll give the floor for the introductions. So starting with the University of Chile, Ms. Loyola.
May I confirm that I'm audible first?
Yes.
Okay, I'm Javier Loyola from University of Chile. I'm on my 5th year of law school. That's the last year here in Chile. And I hope we have a very good debate between each other. Thank you.
Thank you and welcome. From the Hague University of Applied Sciences, Ms. Misawi.
Hi everyone, I am Isawi. I'm representing THIULDT. Are we supposed to give the shout out?
No, just for the
No.
introductions right
Okay. Okay.
now. Right.
Guys, I'm really looking forward to this debate.
From University of Chile, Mr. Mundaka.
Hello everyone, my name is Alejandro Mundaca. I am currently in my 4th year of law school at the University of Chile, and I wish you all good luck.
Thank you and welcome. Ms. Mikna of Hague University of Applied Sciences.
Hello, my name is Julia, and I'm second year student, and I'm looking forward for this debate.
Welcome. And Ms. Reyes of the University of Chile.
Hello everyone, I'm Catherine and I'm actually preparing my final exam in the career and I'm very excited to meet you all.
And Mr. Olalawi from the Hague University of Applied Sciences.
Hi everyone, my name is Hassan Al-Alawi and I'm so excited to meet you all. I'm currently in my 2nd year of law school here.
You're welcome. So in a few moments, you should be able to see the wheel for the allocation of position. As we wait for it to be shared, I would also like to thank the 3 judges for today's debate that we'll be reviewing. And in a second, yes, we have 4 possibilities, 2 for each team in favor and against, activating now. And for today's debate, it is the debaters of the Hague University of Applied Sciences that will be defending the in favor position, and the University of Chile's debating team will defend the against position. Thus, on the topic, the global classification of gig economy workers as independent contractors undermines international cooperation on labor rights, the Hague team will start with the opening statements. You now have final 5 minutes to finalize your preparations, of course. Feel free to close your cameras and we'll start with the team in favor. Well done, everyone. And the time for final preparation has now passed. Well, before we start, just a short reminder, make sure you can see my colleagues, Mr. Sanchez Cortez Macias' video, as he will be giving you visual cues. Yellow for 30 seconds and red for when your time is up. All right, and thus without further ado, Hague University of Applied Sciences team, for your opening statement, you have 4 minutes.
Honorable judges, imagine working 12 hours delivering food or driving passengers, yet having no guaranteed wage, no social security, no employment protection, while the platform controls your prices, assigns your tasks, and evaluates your performance. For millions of workers in the gig economy, this is their everyday reality. This debate asks a simple question: can international labor protections function effectively when millions of workers fall outside the legal category those protections were designed to protect? For the purposes of this debate, we define the gig work as task-based work through digital platforms where individuals provide services such as ride-hailing or delivery, while classified as independent contractors rather than employees. My name is Julia, and with my teammates, we stand in the support of this motion. We'll show this through 3 points: the exclusion of gig workers from labor protections, fragmentation between global platforms and national regulation, and the shifting of economic risk onto workers. First, classifying gig workers as independent contractors excludes them from core labor protections, such as minimum wage, unfair dismissal safeguards, and social security benefits. Labor law is built around the employee-employer relationship, meaning workers outside this category fall through legal gaps. Courts have recognized this in Uber BVU versus Aslam. The UK Supreme Court ruled that Uber drivers were workers, stressing that employment status must reflect the real working relationship, not the platform's label. Secondly, the gig economy is global, while labor regulation remains national. Workers doing the same job on the same platform may face very different protections depending on where they work. This fragmentation makes it difficult for institutions such as International Labor Organization to coordinate global labor standards. This issue is growing. The EU had around 28 million platform workers in 2022, expected to exceed 40 million in the coming years. Finally, platforms shift economic risk onto workers while maintaining control. Workers provide their own equipment and cover costs, while platforms control pricing, allocate tasks through algorithms, and monitor performance. Honorable judges, when workers are excluded from protections, regulation becomes fragmented and risks are shifted onto workers. International cooperation on labor rights cannot function effectively. For those reasons, we respectfully urge you to support the motion. Thank you.
Thank you very much. We'll now hear the opening statement for the against position by the University of Chile. 4 minutes.
21st century world cannot be governed by 19th century factory laws. Welcome, honorable judge and colleagues. Today we strongly oppose the motion. To prove our case, we will present two main arguments. First, the principle of freedom of contract and the failure of the binary system. And second, we will demonstrate that international cooperation is not being destroyed, but is evolving through new legal solutions. Our primary claim is that the independent contractor classification protects the fundamental right to freedom of contract and the free organization of work. The traditional labor system is binary. You are either a dependent employee or a company. But the gig economy has created a new reality. As international employers organizations point out, collaborative platform work is a freely organized activity. It cannot and should not be captured by traditional employment law. Imposing the employee category on this worker will destroy their independence. Forcing them to fit into a rigid mold will violate antitrust law and destroy the very flexibility to attract millions of people of these sectors. It is the imposition of obsolete law and that affects the worker, not the contractor classification. To bring us to our second, regulatory evolution. Our claim is that international cooperation is not being undermined. It is innovation of created a third way. The evidence shows that legal systems are adapting without destroying the contractor status. We have clear legal precedent. In California, votes Proposition 2022. This law explicitly keeps drivers as independent contractor but create a safety net of minimum benefits. In Europe, countries like Spain have created the trade status for economically dependent self-employed workers, granting protection without removing their commercial freedom. Even at the international level, we see real cooperation. The International Road Transport Union and the International Transport Workers Federation have cooperated globally. They are create platform networks that meet high quality standard without changing that legal classification of work. At the end of this debate, you must wait to legal approach. The affirmative teams defends a world that look to the past, a world that force new technology to fit into rigid and complex contracts from the last century. We defend a world that look to the future. We defend the freedom of contract, the innovation of a third way, and an international cooperation that evolves alongside its people. For this reason, we oppose. Thank you.
Thank you. We have heard both opening statements. Now for the first rebuttal for the in favor position, Hague University of Applied Sciences. 2 minutes.
Good morning or good afternoon. The team arguing for this motion, or sorry, against this motion, wants you to believe that by reclassifying a lot of of gig workers into employees rather than independent contractors, that we are attacking the freedom of these workers to contract and find their own jobs and maintain their flexibility that gig work provides. However, this is not the case. What we are arguing for, rather, is to avoid the series of rampant misclassification of individuals who are gig workers, who are currently classified as independent contractors, but in reality, because they are under the direction and control of a central authority, where they have to follow certain standards and contracts and must conduct their jobs in the way that their authority or the employer wants them to do, that they are actually employees. For example, over 5 million of the 28 million gig workers currently in the European Union that my colleague mentioned are misclassified. These are individuals who are not receiving the rights that they should be receiving as employees, such as the right to a minimum wage, the right to being protected from unfair dismissal, and other rights, because they are an independent contractor. We believe that, yes, genuine self-employment and independent contracting does exist, obviously, in this modern day economy. However, companies and platforms may exploit this by labeling workers as self-employed, even though they work under the control of another authority. Furthermore, we just want to make one point clear. The 5 main signs of control that have been shown in Uber v. Aslam also include the fact that the company sets fares, dictates contract terms, limits the abilities of their employers or the employees to conduct certain activities, and these are all shown by modern day platforms. Thank you.
Thank you. For the first rebuttal in the against position, University of Chile.
Thank you very much. Even if the opposing side claims that independent contractors lack guarantees, that argument simply does not reflect the reality of international labor standards. First, protection in the modern world of work are not limited to traditional employee status. Instruments like the International Labor Organization number 190 clearly extending protection against violence and harassment to all workers, regardless of their contractual classification. This already shows that rights are evolving beyond rigid categories. Second, the United Nations established guiding principles on business and human rights, which establish that states have a duty to protect, companies have a responsibility to respect rights, and victims must have access to remedies. Crucially, this framework applies even without reclassifying independent contractors as employees. This is a conclusion that also the jurisprudence is support this argument. For example, even if the United Kingdom Supreme Court in 2021 fails in the case of Huber versus Alam, in 2023, in another case, the results were very different. This support the idea that platform workers are independent contractors. Why? Because, for example, in this case, it's recognizing that independent contractors are a distinct category that still enjoy protection and demonstrate that the issues is not lack of rights, but rather how those rights are implemented. So this shows that there's not only international treaties or convention in this matter, but also jurisprudence, also from the United Kingdom Supreme Court and the European Court of Justice. Thank you very much.
Thank you. For the second rebuttal for the in favor position, 2 minutes.
Am I visible and heard?
You are.
Thank you. The team arguing against this motion wishes to argue on the basis of jurisprudence that, yes, individuals that are self-employed and are gig workers do actually enjoy protections, such as, of course, the right due to the responsibility to protect by the member states of the ILO, and as well as that by the companies themselves that are employing them. However, this idea is fairly limited in reality. Now, the reason for this is due to the fact that labor protections at the end of the day, so the essential labor protections at the end of the day, don't extend to this day in majority of member states and majority of states overall towards the gig worker. For example, when an individual is a self-employed person and wishes to seek Social Security in the United States, they have to pay 12% of their income towards this, whereas employees only pay 6%. It shows a key disparity between the self-employed individual and the regularly employed individual, and this creates a unfavorability of gig work overall. Secondly, there are cases that do highlight that independent contracting should not be the treatment that self-employed but economically dependent people have. In the case of FNV Kusten Informatie versus the Netherlands, the Court of Justice of the European Union recognized that workers who are formally employed but are formally self-employed but economically dependent on their employer should be treated as employees, making it harder, if you don't look at this case, to enforce labor standards across jurisdictions due to the disparity in the way that employees, self-employed employees, are treated throughout. Thank you.
Thank you. For the second rebuttal in the against position, University of Chile.
Thank you very much. Here we are in front of a new category, that is according to the evolution of technologies and the society. But here we are in a situation when these independent contractors have rights and have guarantees. Even if the state have the sovereignty and liberty to establish different legal frameworks for these workers, we have to have in mind that the international law have regulations in this matter. Even if they're not specific a category like independent contractor in the treaties, this can be extended to this new category. For example, the Convention 102, which promotes a adaptable system of social security of the International Labor Organization. Also, the Recommendation 202, which called universal social protection floors, meaning access is based on need, not employment status. Also, the Convention 155, which sets minimum occupational safety and health standards that countries can adapt to different labor arrangements, including independent work. As I already said before, we have also jurisprudence that shows that these kind of workers has protection, but also have a different liberty that cannot be under the category of a simple employee. Because, for example, in the case of the United Kingdom Supreme Court, which is the Independent Workers Union of Great Britain versus Central Arbitration Committee of 2023, the court summarized that delivery riders were not workers because for the relevant statutory collective bargaining regime, delivery allowed substitution and did not require, for example, personal service without an employment relationship. They could not rely on Article 11 of the European regulation of this matter. Thank you very much.
Thank you. This now concludes the rebuttals. We will now hear the concluding statements for the in favor position, the Hague University of Applied Sciences.
Honorable judges, this debate is not about technology, innovation, or the convenience of an app-based work. It is about a far more fundamental issue, and that is whether millions of workers can be excluded from labor protection simply by being labeled independent contractors. First, it places gig workers outside the protection that international labor law was designed to guarantee. The standards prompted by the ILO, including fair working conditions, collective bargaining, and social protections have historically been enforced through employment relationships. When workers are systematically classified as contractors but are being controlled as an employee and have a great reliance to their employers, those protections become difficult and often impossible to enforce in practice. Second, it enables regulatory fragmentation across borders, proven by the opposition when they mentioned the jurisprudence in different countries and how they don't align. The ILO is a UN agency, explicitly acknowledges the concerns and challenges of this fragmentation. Gig platforms operate across borders, but labor laws remain national. The European Union also adopted the Platform Work Directive precisely because widespread misclassification had left millions of workers without adequate protection. In Uber BV versus Islam and Deliveroo and Netherlands BV versus FNV, the court had to determine the issue of whether the Uber drivers were workers due to the lack of clarity of their rights and protection. Finally, platform shifts economic risk onto workers while retaining control over their work. Workers bear their own costs and income instability, while platforms set prices, assign tasks, and monitor performance. When companies exercise employer-like control, but labor works are mentioned as independent contractors, this is not independence. It is misclassification. Thank you.
Thank you. For the concluding statements in the against position, University of Chile.
Okay, honorable judges, as this debate concludes, the central question about technology itself, well, it is not about it. It is about the international legal architecture. The proposition argues that independent contractors' classification undermines cooperation by putting workers outside the rights. However, we have proven that this classification does not preclude international protection. It simply demands a more modern, flexible approach. The core clash today was rigidly versus reality. While our opponents rely on the 2021 Uber versus Aslam case, we have encountered with the most recent and definitive precedents. In the 2023 the liberal ruling on the UK Supreme Court and CTEU Jodel case, these judgments have established that workers possess a genuine right of substitution. They are not subordinate employees, but independent providers. This does not mean that they are unprotected. As our team argued, international law is extensible. ILO Convention number 155 provides a fundamental framework for occupational safety design, especially for flexible implementation covering the world of work beyond classic employee status. Furthermore, international cooperation is not undermined. It is evolving around the UN guiding principles of business and human rights, which includes a duty to protect on states regarding regardless of the labels. The upcoming 2026 ILO Convention platform work is the ultimate evidence that cooperation is alive and well. It proves we can create global floors for decent work, including algorithm transparency. It proves we can create it, and including algorithmic transparency without a mandatory reclassification that will trigger the barriers and kill the flexibility these individuals freely choose. We defend a third way that protects human dignity while respecting the freedom of contract. Therefore, we proudly beg to oppose. Thank you.
Thank you very much. This marks the end of your day 3 debate, and it also marks the end of your first phase. Well done. You can all now relax. You're no longer under evaluation at this point. As always, the judges do have the time to review and submit the scores, but already now we would like to invite you to share your experiences both with the research, perhaps during this exchange, if you heard familiar arguments from your own research for the opposing side, and thus starting with the University of Chile, Mr. Mundaka.
Yes, the topic, in my experience, is very emotion, and it means a really change, but because it's a, a very very important in the situation now, and for this is a really change. And thank you for opportunity.
Thank you very much. Now passing to Ms. Misawi of the Hague University.
Hi, can you hear me? Okay. So the topic itself was actually very intriguing to me because I want to get into like commercial law and competition law, etc., and just labor law in general. So it was very nice seeing how you can put different kinds of perspectives in this issue because you have the gig economy that is genuinely increasing, especially after COVID, but then you have the labor rights that are being affected by it. So it was nice like preparing for both sides. I will like honestly say that we did have arguments prepared for the same arguments that they have mentioned. So that was funny to see, like very nice. And yeah, besides that, the experience was fun. I liked it. I liked working with my group. It was super cute, super fun. And yeah, I really enjoyed my time. Thank you.
Thank you, Ms. Loyola. How did you find the exchange today?
Oh, it was definitely something great to investigate. I really like this topic, especially labor rights. I'm currently on, I don't know how you say it in your countries, but we say like litigation clinic of labor rights. So I'm really into it. We literally discussed this yesterday in class. And about the arguments we had, well, we had some rebuttals ready for it, specifically the Aslam versus Uber resolution. So Well, that was one point that we had ready, but there were some that we had to sort of make an improvisation from that. But it was really funny, actually. It makes us think outside the box. Thank you.
Thank you, and well done during the debate, really, for both teams. Ms. Michna, how did you find the exchange today?
I really liked it. As Aya said, I agree with her that it was really interesting topic. I think I enjoyed them most so far from the three matches we had. And about the argumentation, when we're preparing, I think maybe we're hoping to get the against sides because we really liked preparing to that. That's why I think we're also good prepared in the rebuttal for that. And yes, I don't know, I really enjoyed it. And yeah, thank you.
Yeah, well done. Ms. Reyes, how did you find the topic and the exchange today?
For me, it was really interesting and it was an entertaining topic. Was very different from the other topics that we have in the previous match. For example, I found more easy hard law and case law. There was a lot only in Europe and the United States, but there was. Was also very interesting because, for example, in Chile, we have regulation in these matters, especially for Uber drivers, and it's a current topic. So was very interesting to watch because it's something that is changing through the time, and that was something that we were talking just before the match. For example, the convention that is established by the ILO for June of this year. So it's a topic that is not completely uh, development. I don't know how to say the word, but there is currently in develop. I don't know how to say it, but it was a really fun topic.
Thank you. And Mr. Alalawi of the Hague University of Applied Sciences.
Hi. I really believe that like we both teams prepared very well, and I really enjoyed listening to the opening statement and the rebuttals by my colleagues in that team. I just want to give you guys props. It was very well done overall, and although there were some arguments that we did hope that you guys did mention and that were mentioned, there were some, of course, that weren't. And yeah, thank you so much.
Thank you. And once again, really well done to the two teams. You have had quite a challenge over the debates for the group phase. And it's been a pleasure for the organizing side to see the progress between the first one and the current one. And on that note, we would like to take the opportunity for the last match of the group phase to give you a space if you want to give a shout out to anyone that supported you or encouraged you during the competition so far. And first passing to the Hague University of Applied Sciences.
May I start? So shout out to Mr. Lorange, shout out to our coaches. sorry. Okay. No, but seriously, shout out to the whole tournament. Shout out to Mr. Lorange. I really like the fact that he's organizing this. Shout out to our coaches. They are genuinely putting blood, sweat, and tears into this with us. Shout out to our team members. I am really enjoying the fact that we get to spend time like this. Very educational, very demure. And then besides that, shout out to everyone competing in this tournament. The girls are all gorgeous, I swear, and the men, they're gentlemen. Yeah. But yeah, I'm really like enjoying it. And so shout out to everyone. Shout out to peace on the world. Thank you.
Yes, your colleagues, if you would like to acknowledge anyone from.
I'd like to give a shout out to our coaches, Mr. Khalil and Miss Montero. They really helped us, and especially me, with preparing for this debate. And of course, to all my team members who also spent countless hours motivating and helping out.
Right, thank you. And for University of Chile, over the days of the debates. Who would you like to give a shout out to or acknowledge for the spot?
Well, we actually had some troubles. I don't know if I can say this here. I hope they don't see it, but our coach, she abandoned us. So we were practically no, we were actually making this all by ourselves. We had no one like working with us. We were just the three. But anyways, I think we overcome that. And I really appreciate the work that Corrects Foundation gets in it. I really appreciate the works of all the directors. And well, the communications have been quick and everything. I really appreciate also the teams that we have opposing us, the teams we compete against. They were very well prepared and it was really challenging, and I like that. That's the idea of the tournament, at least for me. I want to learn more. And yeah, that's it. We really like this tournament, and we're really proud to say we did our best job, and I think the other teams did it as well.
Also, your colleagues from the team, if you would like to add on. And it's really, we have heard the shout outs for the team members quite well, so it shows the teamwork that you've put together. All right. Well, on that note, then passing the floor to my colleague, Mr. Sanchez Corses Macias, for the final question of today's session, and then we wrap up officially for your group phase.
Thank you very much. Congratulations for today's debate. So the question is there a legal system, country, or institution and an area of law that you would particularly like to study or experience? And if so, for what reason? So I will first give the floor to the Hague University. You can take the floor, Ms. Michna.
I'm really sorry. Could you repeat the question?
Yes, no problem. I'm sorry. So we would like to know if there is a legal system, country, or institution, and also an area of law that you would like to study or experience. And if that's the case, for what reason?
For example, what you have experienced between day 1 and day 3 or from your own curriculum.
Yes, so you're asking what, for example, area of law would be nice to debate about, or?
No, in your future careers, perhaps if you're interested to explore a bit more, or if there was a particular topic that took your attention.
Yes, so I definitely liked the topic related to today's debate. I think I'm more interested in the area of private law. That's why I enjoyed it probably a bit more. However, I do think that there are also a few nice topics that were mentioned in the last year debates that were really interesting for me also. And it was about the medicine, like about the medicine law. Yes.
Right. For your teammates, if you also would like to share briefly. And
Personally, I'm very interested in international commercial law. So, for example, this topic and the topics that we've had so far in this debate have really intrigued me. And yeah, that's the field of law that I would like to focus on in the future.
And then for me, I think it would be the same. I really like advising, so I think I would go into international commercial law too. Or, yeah, actually, no, it's just private law or international commercial law. I really like the advising part and regulations, etc.
and for the team of University of Chile, area of law or perhaps legal system in particular that you would like to explore more?
I really like the United Nations system. I think that my dream job is work in a institution regardless relation to that. Actually, I took a course of the United Nations last year, so it's something that I'm really passionate about, especially human rights. I think that something that I really enjoy and that I think that need more support around the world, especially with all the human crises that we're current living. So that's the area that I really like, international law, but mostly regarding to human rights.
Great, colleagues, if you would like to also share.
Thank you. The area I like most specifically is criminal law in general, and this is my area. And the area I most enjoyed exploring in these phases was this one, as I found it very current and challenging for the future, and that is why I enjoy the process of searching for information and challenging myself. Thank you.
I like I like a lot of private law. That's my thing. I thought I like criminal law. Then I was like, no, I don't like it. And right now I'm making my thesis about international, AI. So I just say in English. Sorry, I was thinking in Spanish. And I really like how it can be applied to law. And I'm usually searching for new information. And well, uh, I'm really sorry about it because the only information we have is about northern nations, and that's kind of sad. Uh, but well, that's what I'd like to do. And the topic I liked the most was the last one. We were debating about cyberspace. Um, and that's something, yeah, very current in our country. And well, it was really fun to investigate. Thank you.
Thank you. Thank you everyone for sharing. And we wish you really all the best for going further and to explore. And of course, this is not the last CNO, so we also see each other for the group mid-edition break networking event. So keep an eye out on the emails for that. And you will have opportunity to meet your fellow opponents from the group phase, but also from other groups. And just from what I remember from others, you will meet quite a few like-minded students in regards to your fields of interest. So that is a possibility to stay in contact also throughout jurisdictions and for your future growth. And once again, really well done for your group phase. Congratulations, and wishing you all the best for the rest of the day. Goodbye.
Thank
Have a
you.
good